today we are talking about estate planning. Very important topic. A lot of people don't do it, particularly the Black community. So we have an practitioner in-house who can lead us and guide us there in that direction with some laws and all that good stuff. So we want to welcome Benjamin Herrig. Being as a wealth management consultant for Commerce Trust Company, he facilitates the introduction of our prospective clients to a comprehensive service team, which includes private banking, investment management, trust administration, and financial planning. Ben also is a member of Missouri and Kansas Bar and is active in a number of professional organizations, including Estate Planning Society of Kansas City and the Children's Mercy Hospital Donald H. Chisholm Planned Giving Council. He got some other credentials, y'all, but it's a long
mouthful,
list,
right?
So, Ben, welcome.
Thank you. Thank you for having me.
Yeah, we appreciate you coming. So, this is something you've been practicing for quite a while, right? Talking about estate planning. So what is an estate plan?
Well, an estate plan it's a roadmap for what you do with your belongings, assets, possessions. It's not just for those that have millions and millions of dollars. It's for anybody who has stuff. And what an estate plan does is it collects your thoughts and arranges for what happens to that stuff at your death or in the event of incapacity.
I'm glad you said off top that it's not just for wealthy people.
Exactly.
T and I were having this conversation and she did bring it up and started doing her own planning. And I'll tell you, the first thing out of my mouth was, I ain't got nothing to be doing no estate planning for. And one thing she said that actually changed my mind was, okay, so what would happen to your house if something happened to you right now? So that just like, ooh, I don't know. So
very good, T.
Thank you very much. No.
So what would be the first thing somebody would need to do if they wanted to start estate planning?
Well, I'd say the first thing someone needs to do is take an inventory of all of their assets and belongings. And once you've got that inventory taken, begin to think about who you would want to have those belongings, those assets, those bank accounts, investment accounts, car, house, personal property. Who would you want to have that in the event something happened to you? And more importantly, who would you want to be in charge of those things in the event of your incapacity before death?
Wow. Yeah, because if you don't do these things, it might be somebody you don't want, right?
If you don't do these things, the court or the state are going to designate somebody to do them for you, and that doesn't always align with who you would pick to have these things done for you.
It's somebody you trust, most definitely.
Yes,
yeah.
Yes, and it can be a loved one, can be a child, parent, brother, sister, neighbor, friend. It can be a professional, it can be a bank, can be an attorney. There's really no limit to who it can be, but someone that you trust and that you're close to and that will carry out your wishes.
And so if it was a bank, you would pay for that service?
Yes.
9 times, yeah.
Yes.
Mm.
So how about walk us through? I mean, we've done it. Me and my husband have done the estate planning, but how about you walk us through that journey of what a person would do? Sure.
Well, and I'll give you a typical evolution of estate planning, which does not necessarily fit everyone, but when somebody gets married or somebody has a child is when they initially start to think about what's going to happen to my stuff in the event something happens to me, and naturally it would be the spouse and or the children if there is a spouse and children. Otherwise, it might be a parent, it might be a friend, it might be a charity. But beginning to think of what you have, who you would want to pass that on to in the event something happened to you, that's the first step. And once you've identified what you have and who you would like that to pass to in the event of your death, or who you would like to manage that for you or be responsible for you in the event of your incapacity, then it's just a matter of putting your plans on paper.
Do you typically see this being done at a certain age?
The typical evolution, I'll say, is it's thought about at marriage. It's put into place maybe when the birth of a first child. And then oftentimes it gets neglected for a period of time until people start approaching retirement or until they've had an event, a life event happen, a death, a divorce, birth of another child, death of a child, whatever that might be. People begin to revisit this. But if it's done properly, it's not something that you need to look at every single day. It's something that you take stock of and then make changes when there is a change in your life.
Because you have to feed it, basically.
Correct. It's only as good as the last update. And so if there's been a significant change in your life, then you should at least look into whether that warrants a change in your estate plan.
So I know I mentioned the wealthy, and I know a lot of us consider that it's just for wealthy, and I think I've read something that said it's actually probably more important or equally important if you have like a smaller estate because of the final expenses and different things like that. So can you talk just a little bit about that, some of the things that might be included in that, so that I want to capture the audience that thinks that it's not important to them or that they don't have enough to put in there.
Sure. And I will say estate plans come in all shapes and sizes. So there's not one perfect estate plan that's right for everybody. And there's not one perfect estate plan for someone who has $10 million versus someone who has $1,000. There are lots of different ways to pass your belongings and assets on to your beneficiaries. It doesn't have to be a will. It doesn't have to be a trust. It can be joint ownership. It can be transfer on death. It can be beneficiary designations. And so, again, the level of wealth or the level of net worth that you have doesn't dictate the importance of the estate plan. But what is important is that you properly title assets and belongings so that they go to the people you want them to go to when that time comes.
You like your kids.
If you want your kids to have things, then yes.
Or just who cares for them, right? If something happens to you too, it's like a husband and wife, or both. Something happens to both parents. Like, who cares for your kids? Would that be included?
Yeah, and I should have spent more time on that a minute ago. But typically, when someone has their will drafted, it might be at marriage, it might be at the birth of their first child, and whether you got $1 million or $1 to your name, the most important decision you're making at that point is who is going to take care of my kids in the event that my spouse and I are unable to do so. And if you leave that up to the probate court, it might not be the person that you have designated. My family situation is an example of that. My wife and I have discussed who would be taking care of our children in the event something happened to us. And I'm not sure how the court would come out on that, because we've got a number of family members and friends that are close by. We've got another number of family members and friends that are not close by. And so I would like to think they'd ultimately arrive at the same place, but there's no guarantee of that. And so regardless of how much money or how much wealth you may or may not have, I think most parents would say, I want to pick the person to be taking care and raising my children.
Yes.
So that's typically for a young family one of the most important decisions that they will make.
Yeah. So that's why I wanted to bring that up, because if you don't have a lot of money or net worth, you think that you don't need an estate plan, but thinking about those children is very, very key to me, because you might not want some people raising your kids.
I know I don't want some people raising my kids. The other thing that I will add to that is even for people that don't have kids, or maybe their kids are grown, but whether it's husband and wife, same-sex marriage, somebody that's single that doesn't have any children or close family members, identifying who's going to take care of you in the event of your incapacity, who's going to follow your wishes, who's going to know which healthcare decisions you want made for you in the event that you're, on life-saving medical equipment. That's just as important to me as naming who's going to be taking care of your children.
Yeah.
And so you want to be the person ahead of time to pick who's going to be taking care of you in the event that you can't make decisions for yourself.
Yeah. Because, child, somebody be like, go on, get them out of there, pull the plug.
Right. And if you don't have those conversations.
Right. Yes. And if you have money or, just any of that stuff, people.
You're left at whose mercy?
Yeah. Whose
Correct.
mercy?
Correct. Most people say, I want to pick who's taking care of me, or I have a close, spouse, child, parent, brother, sister, close friend. I know that they're going to look out for my best interest because we've talked about what I would want, what directions they would take, what medical treatment they would consult with the medical professional for. So, by having those conversations ahead of time with those individuals and by laying out on paper which steps you want taken on your behalf, it gives the court, if it gets to that point, a clear indication of what your intentions are. Hopefully it doesn't ever get to that point, but in the event that it does, you've laid out your wishes. And there's a lot of famous, I won't get into them, but there's a lot of, when I was in law school, there was a very prominent case about a husband and wife in Florida, the Terry Schiavo case. And that was, made national news because of the condition she was in. And she hadn't properly executed who would be taking care of her in the event of her condition. And it dragged on and on and on. And it was an ugly situation.
It was. I remember that.
So can a person just go to the internet and print off papers and fill them out and have them notarized and that be that? Or what's the process?
I would, this would be my legal disclaimer. I would always say consult with an attorney. But yes, there are websites that can be found that have form documents that would cover most situations. To be honest, they might not cover every situation, and everybody's life is unique. Those are good starting points to understand what should be in a document, whether it's a will or a living will or a power of attorney. So certainly there are resources available online that are quality resources, but knowing what is and what isn't is a challenge.
Okay,
and I'd always recommend, because, I'd like to think most of those websites may not be state specific, and the laws can be different from state to state. So I would certainly always suggest consulting with an estate planning attorney. And that's what we tell our clients every day is, we can't do this for you, but we can give you the names of some good estate planning attorneys that are very experienced in these areas and can help you identify what you need, but also help you identify what needs to go into those documents.
Because I wonder if you run into people that might feel like they can't afford an attorney. And then, is there an alternative? Is there something else that they can do?
Sure. And I think those websites, I don't want to speculate which sites are better than others, but there are some quality websites out there. Even through the Missouri Bar, you can go out and find a form, healthcare power of attorney or financial power of attorney. And like I said, most of those standard forms they will fit, a large majority of people's situations, but again, not every situation, but it's certainly better than nothing.
Right.
And that is a less expensive alternative than hiring an attorney. But you'd be surprised how much of this you can get done from the legal community at a reasonable rate.
Okay. Because I think about, even with using that, if it comes down to needing the document, how technical will it become? If it's something that has to do with somebody is on life support and they need to come on, whatever, is how technical will it become that if they'll use that document or not.
Right. And the more complex the situation, obviously, the more specialized the document would have to be. But again, having something in place is better than having nothing in place.
Yeah.
I wonder if that document would be contestable.
If not executed properly, it can be. Under situations of duress or undue influence, or maybe if there's an issue of whether someone had capacity to execute those documents, it certainly can be contestable, and that's that's not uncommon. But if done properly, you can usually avoid those types of contentious situations.
But it's good just to start somewhere, just get started.
Yeah, and I think the one thing that I will tell anybody that I chat with, but on a daily basis, the one thing that I tell clients is, you're not going to get it exactly right. You're not going to have the perfect document that covers every potential situation that could happen in your lives because there's lots of unexpected situations that occur. But you can get most of the way there. And then, as you revise the document, as your life changes over time, you can cover some of those unanticipated situations, or at least try to cover some of those unanticipated situations.
Yeah. So basically, good things to do is on titles. Anything that you have that's a title is to get transfer on deaths on titles, cars, boats,
houses, bank accounts. A will will only control property that is titled in your sole name at your death. And so if you have joint accounts, if you have accounts that have beneficiary designations, if you have accounts or assets that have transfer on death title, those will pass outside of your estate. Those will pass outside of your will. And so the titling aspect is an important part of any estate plan. And sometimes that can be the only thing that you need. Sometimes a joint account can be the best way to pass an asset to a family member, to a friend, or a house, or a car, or a boat, or whatever the asset might be. And so that can be the easiest and most efficient way to do that. But then what you'd want to make sure you couple that with is the proper power of attorney, so that you've identified who's making decisions for you in the event that you're not able to, because just like a will, a transfer on death title only goes into effect at your death.
Right. Okay. So now I guess I get why they want you to change your title to your trust, because you're saying that's what it transfers to. So if your transfer on death is, you're saying that it overrules, the title overrules.
Correct.
However it's titled.
So you could have the best will or best trust in the world, that you spend thousands and thousands of dollars of legal fees to get the perfect situation. But if your asset's titled in joint name or with transfer on death, then that will or that trust, that doesn't matter.
Right. So you got to make sure your titles are right.
Correct.
Once you set up everything else.
And so that becomes part of the process, is when you've taken that inventory of your assets and your belongings, the next step is to identify how each of those things are titled. Mm-hmm. And then if you have a will, if you have a trust, making sure that those assets are going to pass according to your will or trust based on how those assets are titled, because beneficiary designations, whether it be a retirement plan, a transfer on death title to a vehicle or a house, transfer on death title to a bank account or investment account, that will supersede what your will says, because you don't own those assets yourself, or you don't own the asset in your sole name at your death. Mm-hmm. So there's a bit of a flow to that.
And I want to back up a little bit and just explain what the difference is between a will and a trust, because some people don't understand that.
They're very similar. They both control the disposition of your assets. The trust goes into effect as soon as it's executed, and as soon as you begin titling assets in the name of your trust. The will does not go into effect until you die. And so the trust also protects you in the event of your incapacity, whereas, again, the will does not, because it only takes effect at your death. Mm-hmm. So they're very similar documents, but there are some key differences as well. They both identify who will be taking care of your assets, either at death in the case of a will, or at death and or incapacity in the case of your trust. With a trust, you have to go a step further and title your assets in the name of the trust to make the trust the owner of those assets. A trust might cost you a little bit more up front, but it's going to save you time and money on the back end at death or incapacity. But again, depending on what the assets are and depending on your family situation, they're both better than nothing. Mm-hmm. But those are some of the key differences. A trust is typically much more efficient because you've identified a successor trustee, which is somebody who steps into your shoes and controls the disposition of your assets. With a will, it's called a personal representative or an executor, depending on which state you're in. And they also step into your shoes and dispose of your assets, but they do so with the probate court supervision. And so that by itself adds a little bit more formality and structure to it, sometimes more cost to it, sometimes more time to it. It can be contested because it's the probate proceedings are a public proceeding. So somebody who is nosy or a family member that might have been left out, they can challenge or they can participate in the process. Whereas a trust is a private document and it allows for private disposition of your assets. So there are a number of advantages of both. But as I said, the trust might cost you a little bit more upfront, but might save you money and time and headache on the back end. Whereas the will can be done probably cheaper on the front end, but then there's going to be a little bit more headache on the backside.
I want to throw out the living will as well, because isn't it a little different than?
Yeah, a living will is a document that you've identified what your what medical treatment you want taken on your behalf in the event that you're incapacitated and unable to do so. So yeah, the living will and a will are similar but very different at the same time. So and I think a lot of people get the terminology confused. Just like sometimes a trust is commonly referred to as a revocable living trust. And so when people hear revocable living trust, when they hear living will, when they hear will, when they hear powers of attorney for healthcare, powers of attorney for finances, they can get the terminology mixed up pretty easily.
So you can have a power of attorney or separate people to do somebody for your health care and then somebody for your finances.
Yes.
Oh, sorry, you weren't talking to me.
No, go ahead. I've talked too much.
That's okay. I'm just saying, I be wanting to just make stuff clear for people who are listening so that they just get an understanding of options.
Sure. You can, with the power of attorney for healthcare or finances, you're designating an agent to act on your behalf. Probably the majority of people name the same person, but you certainly don't have to. I might name my spouse as the person to be able to take care of me physically and know what medical treatment I want, and I trust her decision making, assuming that I'm on her good side that day. When it comes to any medical treatment I might need, so I would designate her to act in that capacity. But maybe I don't trust that same person to control the finances. Now, hopefully, most people do, and there's certainly lots of help that you can get out there from advisors, but they do not necessarily have to be the same person.
That's what's up.
Good stuff.
Totally.
One thing I like about, and I've mentioned this before because I think it's funny, but one thing I like about our attorney did with us with the trust is if I die, my husband has to do a prenup.
And she laughed.
I think that's funny.
You would be surprised how many things like that you can find in a trust document. And then the thing is, you can get as creative, as comical, as restrictive as you want to be within certain parameters.
But it's for the children on both sides.
Sure.
Just so
protecting
just so she or he can't come in, somebody new come in and
take everything.
Yeah, and only been around for 5 years. Or, you know what I'm saying?
And that's where you hear the horror stories of the made-for-TV movies because of a situation like that where someone passes away and now you have stepchildren or a second marriage. And there's some pretty entertaining situations.
So what happens if a person passes and doesn't have an estate plan?
Well, the state will make an estate plan for them. So the state...
You don't want that to happen.
The state has it's called the Table of Consanguinity, which is something that I learned in law school and quickly hope to forget. But essentially, the state has designated who is to receive your assets upon your death. And it typically would be spouse and then children. If there's no children, it would be parents. Every state is a little bit different, but it goes all the way out to the nth degree, which is where you hear the stories of somebody inheriting millions of dollars from their rich uncle that they never knew they had.
I'm still waiting on him.
Mine hasn't shown up yet either. But if you don't designate someone to receive the property, then it'll fall back to state statute. And they've got a table which says who receives your assets based on family.
So what's with the probate part? So is it a myth that it goes through probate, or does it go through probate and then it goes to next of kin, or how does that work?
It would go through the probate process. So the probate court essentially oversees the disposition of your assets, whether you have a will or you don't have a will. If the assets passed according to the intestate statutes or intestacy statutes, where you haven't designated somebody, it's still overseen by the probate court. Just like if you have a will, assets that are titled in your sole name will also pass through the probate court, which means the probate court monitors the proceedings. So there's nothing wrong with that by any means. It just can be a little bit time consuming and can be a little bit can cost some money to do so. But if you're concerned about people not following your instructions, it's a good monitor to have in place. But again, that only applies to assets that are titled in your sole name at your death. And so whether you have a will or you don't have a will, any assets that are titled in your sole name will pass through the probate court.
So let's say I have a home and I don't have anything. I don't have an estate plan. I don't have a will. I don't have a transfer on death, anything. And I die. What happens to my house? And I have children. I'm single or widowed or whatever.
Typically, it would go to your children. But again, it might be different from state to state. Usually with intestacy, the spouse and children will share together. So, you just threw out an example where you're single in that example, but sometime, I think most spouses would say, upon my death, everything goes to the surviving spouse. That's fairly common, unless it's a second marriage or third marriage, or there's some other issues there. But most people would say everything I have belongs to my spouse at my death. If you don't specifically spell that out, that spouse might end up sharing those assets with children. And you hope the children will do the right thing and that they will use those assets to take care of mom or dad, surviving spouse, if that's the case, but they don't necessarily have to. And there's no requirement that they do so. And so, that's one of the reasons you don't want to leave it up to chance as to what is the state going to tell you to do, or what is the state going to do with your assets. It's best to have it in writing, which may be a joint account or joint titling on a house with your spouse, as opposed to sharing it between spouse and children. Again, there's lots of horror stories of things gone wrong, but it's pretty easy to do it right.
So it's extremely important to take care of your business, because what most people hate most, which would be me, is for somebody else to tell me what I can or can't do with something that belongs to me.
Or just not giving me what's due, like, period.
Right. And what you think is due versus what state law says is due might be two different things.
Right.
And I'm sitting here wondering, like, in the scenario that T just mentioned, if none of the kids come forward and say, that's my mama's stuff and I want it, do they seek family out, or do they try to find family, or
they would not? They may, to an extent. They're not going to go to great lengths, probably. Even if one child comes out and says, I'm going to collect all of these things and I'm going to give them to my siblings, there may be other issues that come along with that. When we were talking during the break, one of the common scenarios we see is an elderly parent whose spouse has passed away, and they name or put one of their adult children on an account just out of sheer convenience, because that child lives down the street. They help them go to the doctor. They help them pay bills. They oversee the finances. And so they put that person on the account as a joint owner so that they can help carry out those transactions. Well, when that parent dies, if there are other children in the picture, that child that's named as a joint account holder, all of those assets now belong to that child. And even if that child turns around and shares those assets per mom or dad's wishes with his or her siblings, that could have some unintended tax consequences depending upon the dollar amount that we're talking about. So we see at the bank, we see that a lot, where people will title an account with one or more children just out of convenience so that they can help manage the bills, or so that, that's an easy way to pass assets at death. But there can be a number of pitfalls in doing so.
Wow.
The one I just laid out, or any joint account holder can take the assets out of the account at any time. If there are creditors, the account holder, these creditors might be able to seize those assets. And so there can be a number of issues with doing that. And probably a better solution is to have a child on the account as an agent under a financial power of attorney, as opposed to on the account as a joint account holder.
So, in your opinion, is that the same thing as transfer on death? Or
it's not quite the same thing as transfer on death. Transfer on death would only, if I'm on your bank account as a transfer on death beneficiary, I don't have any power or authority to act on your behalf during your lifetime, even if you're incapacitated.
Right.
Unless you've got other documents in place. And so at your death, those assets now come to me. And so for some people, having, if I have 4 children and my spouse is deceased, I might list, one solution might be to list my 4 children as transfer on death beneficiaries equally, so that each of my 4, if I have $10,000 in my bank account, each of those 4 children will get 25% of that, which works perfectly fine if they're all living at my death. If they're not all living at my death and one of them has a child of their own, most parents would want that deceased child's share to go to grandchildren.
Right.
And so a transfer on death does not account for that, which is why it's either important to update the titling of that account at someone's death, or, to spell out your wishes in a will or a trust. Because you can't account for those scenarios in a will and in a trust.
Right. And we have that in our trust. So if something was to happen to one of our children, then their portion would go to their child.
Correct.
And one thing that we were talking about doing, another thing we were talking about during the break was about ages and children not being able to handle certain things or certain dollar amounts at certain ages.
Right.
So we were able to put an age limit on it. So they wouldn't be able to have a particular thing, a particular dollar amount until they hit a certain age.
Sure. And that's very commonly done. I think most parents who have, whether they're minors or, children over the age of 18, will view their children's maturity levels or financial responsibilities at various levels. And so I can say that if something happened to me and I had, $10 or $10 million, my 18-year-old child is not going to properly handle that money at age 18. Now they might at 25 or 30 or 35. And that's for you as a parent to identify when you feel they're financially responsible. It might not ever be, or it might, if you have children that have disabilities, or if you have children that have substance abuse issues, if you have children that have spouses that you might not, the marriage might not survive. If you have children that have, they're in a business or a profession that they might have creditors, or they might be sued because of what they do, then leaving assets to those children outright, no matter what their age is, might not be the wisest thing to do. It might be more beneficial to leave assets in trust for their benefit, and then you can spell out the parameters as to how those kids can access the money or how they can benefit from the money. So, yeah, I think most people think of it in terms of, I don't want my 18-year-old to blow through their inheritance.
Right.
But whether it's 18 or 38
40 or 50.
Yes.
Yeah. So one cool thing about, trust is you can spell it out.
Right. And that's where I mentioned before, you can be creative or restrictive. You in your trust document, you can tell the trustee who's making the decisions on your behalf when you're no longer able to, whether that's death or incapacity, that successor trustee steps into your shoes and carries out your intentions as stated in that trust document. And you've stated how my kids, how your children can benefit from that money. Maybe they can get, maybe you look at it like it's an allowance and they can get a certain dollar amount each month. maybe they can only get it for special situations where extenuating circumstances like a medical emergency, or to pay for college expenses, or to, help with, if they're in maybe they're a social worker or a teacher or a profession that maybe they're doing good in the world, but they're not paid the highest. And so maybe you can benefit them based on the career that they go into. Maybe you can just say, upon graduation from college, I'm going to leave them X amount of money as an incentive to graduate from college. Or, we've seen it where people will do it for the down payment of a house, or the replacement of a vehicle. Again, the sky is the limit as to what you can put into that trust document. And as long as it's not against the law or against public policy, you can be as restrictive as you want to be too. And that's the law school textbooks that I won't get into as far as what is and what might not be allowed. And that's changed over time. But I think every family situation is different. And even each of your kids grows up and matures differently, might have, more or less need than the other. I've got 4 kids. And I don't know that I would treat them all the same. Now, granted, they're all under 18, and I wouldn't give any of them money now. But 20 years from now, maybe 2 of them can properly handle money, and 2 of them can't.
Right.
And so it's important for my wife and I to identify which ones can and can't, and then adjust our trust accordingly. And the nice thing about a revocable living trust is you can change that while you're alive and have capacity. So as your kids mature, as their lives evolve, you can make changes to keep up with that in your trust. And you can do that with a will as well. You can create a trust in a will, a testamentary trust, but you can make those changes along the way as your life evolves, as your beneficiaries' lives evolve.
Great way to, just to that generational wealth, to build that generational wealth. And I don't know. It's something to put on your radar and think about, because once again, a lot of people think, oh, that's not for me, or I don't need
have
that.
enough.
And a lot of people do.
I mean, even just thinking about your children, that alone. And you mentioned something that I had thought about when we talked about children, which were maybe disabled. If you have like a disabled adult child, you just thinking about them, well, who do you want to care for that person too? So that's another thing to consider. I'm just being specific here in our thoughts. So I know I was one of those people that, especially for trust, we just think those are for rich. You hear trust and you think wealth, like period. So I'm glad you're talking about it, and it could be anybody. If you have a house, you have a car, you could do a trust.
You could, and what you'll run into, depending on, I agree with you, a trust doesn't just have to be for the wealthy. What you will run into from a bank's perspective at times is the size of that trust may not be economical for the bank to administer on your behalf, in which case it'd be beneficial to name a family member, a friend, a trusted person to carry out your wishes. And so it can be an individual that carries out your wishes as the successor trustee, and it can be a bank. And so because of the cost sometimes of using a bank, a trust of a certain size might not make sense to have a bank manage, because the costs associated with it might eat into the principal of the trust. But if you have an individual that is a trusted friend, confidant, advisor, whatever the case might be, then that person can act as your trustee just as easily as a bank can. And in some cases, probably more easily. But they might have to hire professionals to be around them to understand the tax ramifications and the investments and some of the decision making that comes along with that responsibility.
Well, I'm thinking it'll be easier to have the bank do it and read the wills and all that good stuff. That way ain't nobody got to be mad at me.
The bank doesn't care if we're the bad guy. If the beneficiary is mad at us, we don't care. We don't have to go to Thanksgiving dinner with them.
Exactly. I'm like, ain't nobody got to be mad at me.
Well, I'll be gone, so I won't care.
and the other thing, I know this is lighthearted, but what we'll see at times is, a parent will name the oldest child to be in charge just because they did it for their parents, and therefore their oldest child is going to do it for them. And, most of the time, parents will hope that whatever money decisions come up, they don't get in the way of that family relationship.
Sure.
And so that's where having a objective non-family member, a bank, or somebody outside of the family might be beneficial, because you don't have brother lording over sister's assets or trust, that they're the trustee making all the decisions, and it results in a contentious family situation.
We did not pick any children to be over it. We didn't pick the children because that most definitely, I don't want any of them, feeling a certain way, and especially try to keep it all equal. But I'm like, no, none of the kids.
Well, and I think my dad has named, I've got 3 brothers. They live 4 hours away, but my dad has named me as the successor trustee of his trust and the executor of his estate. And I do this for a living every single day, but I'm raising 4 kids. I have a job. My wife has a job. I don't live very close to them. It becomes a burden. It becomes a challenge to properly handle that from afar, or from, if you're close by, because you have other things going on in your lives. And so that's where there can be an advantage to having a corporate trustee, having a bank do it, because that's what the corporate trustee does all day, every day. But again, it's not a fit for everyone.
Right.
But you're not, I think that the movies and books make it sound like there's this exciting reading of the will or reading of the trust, and you've tapped child A on the shoulder as being the person to take care of those things, and that's such an esteemed position in the family. But most of the time, it's a unwanted burden because of all the responsibilities that come along with it. So if you can avoid that, it might be helpful to do so. Not only to keep the harmony in the family, but to relieve that individual of that burden. But some people, that's the best solution for them. And so it just depends on what the family situation and what the assets are.
Yeah, and I've seen that harmony be lost because of there not being a plan. You see that happen more often because there is no plan, there is no will, there is no life insurance, and just already grieving for a person, and now you have to figure out how you're going to pay for funerals, or just all of that stress that comes with death. And I've seen it tear families apart, and that is really sad. But being prepared and having somebody else reading that will.
And
to be honest, that doesn't happen all that much in practice, but it's great for a movie line. But the other thing I think, no matter what the dollar amount might be or what the belongings might look like, somebody can, there might be hurt feelings because somebody gets more than somebody else, or because somebody's left out, but it's still best to have that clearly stated so that there's not, ongoing legal issues or ongoing, keep in mind, it's not, if there's 2 children and it's mom and dad's wishes, child A didn't decide to get this for child B. If that happened and there's undue influence, that's a whole nother can of worms. But there could be some hurt feelings, but usually people can get over that if there's a clearly stated directions or intentions.
Exactly.
And there's even been some attorneys that I've seen as of late that have gotten into the more emotional side of estate planning. And so they're having parents in their documents spell out why child A is getting a certain amount and why child B isn't, or why child A gets the money outright in their own pocket to kind of do with what they want, while child B has to rely on a trustee to give them distributions along the way. So that they're trying to tap into that more emotional side of things, where you're explaining why you're doing what you're doing, and you're trying to pass on not only your financial legacy, but your memory or your values or your emotional legacy as well. And while it doesn't always have legal merit, it can sometimes help prevent hard feelings.
Yeah,
I really want to bring this point out again that we talked about, and that is getting a power of attorney over your health is so, so, so important.
Absolutely.
To do, because I have experienced, in talking about your wishes, if you're incapacitated, to talk about it. People don't want to have that hard conversation with their loved ones, and you don't know what the next day brings. And it's so important to have those hard conversations of what you would or would not want, the state you would or would not want to live in, so, and to have the power of attorneys and just not assume certain things.
Well, and that's very important because most people become incapacitated prior to death. If it's for a minute or a year or a decade, as you think about the natural evolution of life, that exists and that occurs, and not having those documents or not having those directions in place can be very detrimental. And not only for you as the person who's incapacitated, but for that person who should be the one taking care of you, or who should be making the directions, making the giving the directions for the treatment on your behalf. If they haven't had that discussion with you, then they might not know what wishes you want or what medical treatment you want and what condition you want to live in. And that can be obviously very stressful. Yeah. The other, with the healthcare power of attorney, the healthcare power, as we stated before, the healthcare and the financial power of attorney don't have to be that same person. But the documents are pretty similar. And so you can find some of those resources online and begin to think about who would be that proper person named under the document.
Sounds good. Ben, thank you. This has been a whole lot of good information.
Yes.
I'll be taking notes again, and I'm here in the person, but I listen to both shows sometime because the information is so rich. So if you want to share any contact information, or if people have questions, go ahead and do that.
Sure. I would just say, again, Ben Herrig, Herrig, sometimes referred to as Benjamin Herrig. But probably the best way to look me up would be on LinkedIn, because sometimes emails get caught up in my spam filter, or phone calls might not get routed to me if I'm working outside of the bank. So LinkedIn, Benjamin Herrig or Ben Herrig would probably be the best way to reach me.
Okay. Well, thank you for coming.
Yes,
this has been so good. We appreciate it.
My pleasure. I hope it was helpful for your audience.
Yeah, I am Simply C, guys. You can catch me on Simply Custom Wood Designs on Facebook and Instagram. You can also catch me on Facebook at Simply Cupcakes, and check out the website advocatingdaughters.com.
And I am Money T. I am a travel advisor. And my website is www.priceless-destinations.com. I have a travel store, and it also has the ultimate packing list. You can go in there and put in where you're going. You'll get the weather. It tells you what to pack and all that great stuff. And I want you guys to remember that your money mindset matters. And as a man thinketh in his heart, so is he.
You can listen to us every Monday
on the 8th. That is 8 a.m. and 8 p.m. Central Standard Time.
You can find us on Facebook at Let's Talk Money. You can search at Girls Talk Money, and you can also find us on YouTube. At Girls Talk Money. We appreciate y'all listening today. We are out.